A letter to Father Stephen Weibel and members of Holy Cross Parish Council and Finance Committee. From George C. Martin, Jr. Delivered on February 21, 2025. Preface. Due to the likely damaging effect the present lawsuit filed by the diocese will have to our parish, I need to have your attention. As you may recall, the diocese took over my management of confronting the state a month before the arrival of Father Weibel in July of last year. For those of you who were not aware of my efforts to get the diocese to respond to the criminal actions of the state from 2012 to 2023, a question to be answered. Why would the diocese suddenly take control of a matter that they had avoided for 11 years? The enclosed documents detail the shameful actions of both the diocese and the state, which, unless altered, will result in a horrible injustice to Holy Cross. Thanks to the recent assistance of a parishioner and former litigator, we hope to salvage what we can from the criminal actions of the state. In providing each member above a copy of The View from Under the Bus and the supporting documentation, I do so with a request. You will note that each copy is stamped with draft and a date, as this is still open for correction and an ultimate resolution. This story is so bizarre in the telling that there must be some mitigating elements that may relieve otherwise good people from appearing to have acted badly and even recklessly. As of this writing, their actions have us mired in a Montgomery County Court debacle. In September of 2023, I attended a HC Finance Committee meeting, during which it was agreed that a member of the Finance Committee would monitor the pending sidewalk eminent domain ED matter. Prior to this meeting, I had advised Aaron Gerard, the counsel for the adjoining developer EYA, that the sidewalk that they had the obligation to install along the entire frontage of Holy Cross was to overlap the state's illegally installed piping. Aaron advised the county of this conflict, resulting in the county stand down on the sidewalk design. Chris Anzadeh, general counsel for the diocese ADW, hired Joe Suntum to pursue the ED matter. However, I had no knowledge that ADW would engage Joe to prepare another claim against the state. I will show that this meritless claim is to indict ADW and to vindicate Holy Cross on its consistent position to get the state off our parish property. Having been thrown under the bus previously by ADW and the newly created team, I was to wait out the year following the September finance meeting with no word on the tasks I had been working on. This termination of my service to Holy Cross, engineered by ADW, has already had disastrous consequences for Holy Cross, with no end in sight. At this time, for over a year I had heard nothing on my decade-old task for Holy Cross, when in September of 2024, at a parish council meeting, I received the original complaint, ADW and HC-V, State of Maryland DOT. This complaint was followed a few months later with the amended complaint. These complaints analyzed here are the very poorest claims I have ever read in my over 40-year career as a construction claims arbitrator. What I have witnessed is that ADW, as owner of our parish property until September 17, 2024, has not only failed to protect their own property, they have conspired with the state of Maryland to our detriment. Not only did ADW fail to find wrongdoing by the state for their brutal violation of our parish property for over a decade, the complaint simply alleges that they failed to pay compensation for something. As you read on, you will be able to see what this something is. The irresponsible actions of both the state and ADW need to be addressed as soon as possible, or Holy Cross will never receive justice. As to the actions and inactions of the diocese, there can be no excuse for their non-response to protect their own property starting in 2012. In ADW's absence, Holy Cross was forced to carry the fight to the state and to bear the cost of restoration. When ADW finally attempted to intervene in my efforts in 2023, they not only exposed their disregard for the welfare of our parish, they exposed their own actions in a cover-up with the state, which is reprehensible. Since I will frequently be using the 2 R's in explaining the state's obligation, the raw way, right-of-way, is the Strathmore pavement and shoulder area where the state is obligated to contain their public stormwater piping. The ROE, right of entry, is primarily a 2-page agreement, allowing the state to have access for the piping to the HC ravine. It is not a conveyance of property agreement to the state. As of this writing, the state has no right to occupy any area within Holy Cross's property. As to the actions of the state of Maryland, they stand alone for their complete disregard for the interest of our parish. Who, including the perpetrators of this crime, would tolerate this happening to their own private property? Discovering that the state appeared immune from having their actions reversed, and that their relentless actions could not be stopped, you can only come to one conclusion. This rogue operation was not an anomaly. It was done systematically and systemically. The state's actions were so skillfully performed that one can only assume that there is a history of similar violations that need to be investigated. I want to acknowledge support from Father Bookmeyer and Father Hughes, Sue Numrich for funding, Cindy Kratz for pressing me to report on the damage and restoration to the parish, Nancy Florine, former MC council member, for convening a meeting of SHA and MC officials, an anonymous former federal DA on his review, my daughter Eileen for editing, and my son George for his research and the discovery that ADW owned the frontage, northern parcel, that ADW did not know they owned, nor wanted to know. The preface, narrative, original and amended complaints, analysis of the complaints and related court documents are primarily contained within this binder. The supplemental binder, presently being assembled, contains supporting historical documents. In the end, you will see that ADW, after having failed to make sense of their demand that the state owes something, concedes to Holy Cross's original position. To complaint, Roman Catholic Archbishop of Washington and Holy Cross Catholic Church, plaintiff, Maryland Department of Transportation State Highway Administration, defendant, dated August 18, 2024. Recognizing that my analysis of the complaint requires a brief history to be fully understood, the following is essential and complementary to my analysis of the complaint. Given that the complaint is written in such vague language, I apologize in advance should I be in error. The failure of the drafter of the complaint to be more forthright about why the state failed to make payment to Holy Cross makes the diocese's actions more reprehensible. Had the cardinal simply called the governor, the state's irrationality would have ended. At the core of this case is that the state surreptitiously allowed the flooding of Holy Cross to take place, beginning in 2010, for the sole purpose to gain access to the HC ravine for their public stormwater runoff. Avoiding any effort to accomplish this task legally, they, SHA, resorted to coercing our cooperation by simply allowing the roadside retention ditches to silt up. The roadside retention ditches, which had prevented flooding for over 65 years, needed regular maintenance, or lower elevation ground would be vulnerable to flooding. The entire frontage of Holy Cross, MD 547, aka Strathmore Avenue, is approximately 1/4 mile in length. One section of this roadway, adjacent to the school recreation field, is depressed, requiring the retention ditches as a control barrier. Unbeknownst to us in 2010, the state was plotting to avoid the very costly piping within their own right-of-way, ROW, by diverting their stormwater runoff through our Holy Cross property. What the state did here to Holy Cross was illegal and reprehensible, but became worse when the diocese, ADW, after failing to come to protect their own property, decided to intervene after I had received admission by the state of their wrongdoing. It had been rumored during the mid-1990s that the state was finally going to try to rehabilitate Strathmore from its present country road status to current standards. Among other standards, the state needed to address their failure to replace the roadside retention ditches with stormwater piping, sidewalks, curb and gutter. When the state set up an advisory board in 2002, Monsignor Gatto asked me to represent the parish, see enclosed, which I did. As you will see, the state bungled this overdue task and apparently left the matter to SHA's Greenbelt office, whose actions thereafter resemble a rogue operation. In 2010, the successor pastor to Monsignor Gatto, Monsignor Hill, alerted me to a peculiar sight at the oval entrance to the church. He observed state employees opening up a drainage pipe, releasing stormwater from across Strathmore to Holy Cross. My review of the matter was much more disturbing, as it appeared that SHA had not been monitoring, mucking out, their retention ditches that protect Holy Cross from being flooded. Upon contacting SHA's Greenbelt office, I was assured by them that they were well aware of the matter, and hopefully their current budget would allow them to address it. I would regularly call SHA for an update, but even their assurances ceased by 2012. Having worked almost daily since then trying to reverse the criminal actions of the state, we fail to get anyone's attention. The covert actions of the state lasted a couple years, as they realized that there was not sufficient pressure for them to stop their flooding. My efforts to enlist ADW, the owner of the property, was met with their inexplicable response that they, ADW, did not have the money to fight SHA. To me, money was not the issue. A simple phone call by the Cardinal to the Governor of Maryland was all I needed. But no, the failure of the property owner, ADW, to take the least effort to confront the state on their criminal actions continues to this day. It is not until count 2 of the complaint that we see any mention by ADW that the state did anything wrong, and that compensation is warranted. For months, the state's agency, SHA, relentlessly tried to access the HC ravine by proposing a partnership with HC to, in effect, alleviate the flooding that they were causing. To add insult to injury, they wanted us to replace the culvert piping under the HC entrance oval that they were clogging up with their Strathmore runoff. When I resisted SHA's effort to allow them to install a rip-rack trench down the left side of the entrance oval, down to the inlet opening of the ravine culvert pipe, things came to a standstill. However, having created a problem for themselves by clogging up the culvert pipe with their runoff, they were forced to bring in their excavating equipment onto our property to remove the buildup of silt at both the inlet and outlet ends of the culvert pipe. Later, when the ravine was overflowing due to the clogged culvert pipe served their duress strategy, they stopped this mucking out operation. Clearly, SHA was now playing hardball, and I was running out of options. Fortunately, I had the cell phone number of the local SHA maintenance superintendent, who had previously performed the mucking out operation. I was embarrassed to have caught him while he was in the hospital, but I told him of our plight. He returned 2 weeks later to continue the mucking out operations. When SHA's Greenbelt office heard that I was engaging directly their employees, they closed down the operation. From that point on, I used my own guys, mostly at my expense, to both muck out the outlet end of the culvert pipe and to try to penetrate the clogged culvert pipe from the inlet end of the culvert pipe. Both of these tactics to free up the old culvert pipe failed. It was clear that we needed a new culvert pipe. As previously noted, by 2012, we discovered that the state had an ulterior motive for the flooding. The state's aim was to coerce HC into accepting their access to the HC ravine, the shortcut. It was HC's position from the start to this day that the state must contain their stormwater runoff within their own ROW. In order for this to happen, the state needed to replace their retention ditches until such time that the permanent piping was in the state's route. The state, fully aware that the 1-acre frontage strip discovered by my son George was unbeknownst to ADW and actually owned by ADW. This 1-acre parcel was to be the primary area for access and the focal point of count 1 of the complaint. We now see in this complaint that unbeknownst to Holy Cross, ADW had been negotiating with the state between 2018 to 2023 when the illegal piping was to be put in place. Holy Cross, as partner to ADW in this complaint, was knowingly excluded from these discussions. The complaint makes no reference to the active role that Father Bookmeyer and I played to eventually stop the flooding and to restore the Holy Cross property. ADW played no part in either confronting the state or assisting us in any way. At an impasse with the state, Father Bookmeyer advised me to use any method I could to stop the flooding. As stormwater was now almost up to the school doors, it was no longer just a property damage problem. The school children were clearly now in mortal danger due to the reckless actions of the state. With the arrival of a new administrator taking over the SHA Greenbelt office, I tried a new approach. It was my belief that any actions the state would need to take to get to the ravine would be extortion, as the stormwater was public, not Holy Cross, and we neither wanted nor were offered compensation. After months of wrangling, I was able to get SHA to agree in principle to piping their stormwater across the church entrance driveway and routing the stormwater down the right side of the driveway to the ravine. This new arrangement would eventually produce the 2018 Right of Entry ROE agreement. Therefore, from 2010 to 2012, deceit by the state and abandonment by ADW. From 2012 to 2018, we are doing damage repair and efforts to keep the culvert pipe open. From 2018 to 2023, the signing of the ROE agreement with the attached piping plan, with pipe installation in 2022, and my restoration of the Holy Cross property, allowing for an opening of the 2022 school season. Without Father Buckmeyer's support in allowing me to use the Holy Cross Campaign 60 funds, headed by Sue Numrick's efforts for unrelated work, the restoration could not have happened. I hired an excellent civil engineering firm to design the culvert piping replacement and a very economical contractor for the culvert replacement, followed by curbing, sidewalk, paving, sealing, and landscaping. I was then able to resist the state's actions and to manage the restoration of Holy Cross. However, not only did the owner, ADW, fail to show any interest in protecting their property, nor any appreciation for the work that we had done on their behalf since 2012, their actions were inexplicable. If they were allies with us, why were they not expending any effort to confront the state, to reverse their criminal trespass, and ultimate property confiscation. As to the 1-acre frontage parcel that George discovered, the original complaint spends most of count 1 on this distraction. Yes, it is true that the Strathmore parallel piping was placed more deeply into the Holy Cross property than shown on the plan. But this would prove to be of no importance. The eminent domain action for the sidewalk, 10-foot side path, and 6-foot planting area was certain to cover the present illegal piping running parallel with Strathmore. Why ADW would raise this issue of little consequence when for years the state was destroying Holy Cross property without ADW doing anything remains a mystery to me. Responding to my request to Mary Rhodes, attorney for ADW, to ask the state to provide proof of ownership of the 1-acre Strathmore frontage parcel where the piping was placed, the state failed to show proof. That did not stop ADW from communicating with the state on this settled matter, apparently hoping that the state would find a rationale for their trespass on this strip of Holy Cross property. Up to 2022, I was exclusively occupied by the reckless actions of the state when I was drawn into the possible negative impact to Holy Cross of the pending EYA development next to Holy Cross. This development was to occupy an area almost 50% larger than Holy Cross, and to require the developer to install a sidewalk on Strathmore for the entire frontage of Holy Cross. When I was asked to join a Zoom presentation by the counsel for EYA, Aaron Gerard, I was pleased to do so, as Holy Cross had 2 concerns related to this development. The first concern was related to the significant size of their primary building, Brandywine, needing mitigation so as not to leave Holy Cross in its shadow. While we were to spend a great deal of time and money with our engineer developing various vegetative mitigation solutions, I can honestly say that no solution could achieve what I was looking for. Not only was the building size a major distraction, but the loading dock area was to be in close proximity to the rectory, adding issues of noise, odor, pest control, lighting, and hours of operations. I would like to think that our unanswered concerns eventually led EYA to withdraw Brandywine from their plans, but I think interest rate increases and marketing data were likely the major factors. For whatever reason, we were much relieved to see Brandywine go. As to our second concern, EYA had assumed that the Holy Cross 1-acre strip was public property and planned to veer their sidewalk deeper into our space than they had designed for their own frontage. The Holy Cross recreation field is long in the east-west roadway direction, but narrow in the north-south direction. So we are vigilant and prepared to fight should the planned curb-to-back of sidewalk setback be any greater than our neighbors. Ever since ADW's illegal termination of my service, I had not been kept current on what the county was doing on the sidewalk issue. Previously, I had been contacted by the County Planning Board on their desire to take more of our ground for a 10-foot wide side path, aka bike path. I spent a great deal of time on this incursion, and in the end was able to prevail in holding the same setback as the Academy of Holy Cross and the town of Garrett Park. Now, with the EYA's need to resubmit their rezoning application because of withdrawing Brandywine, EYA is required to have the side path. Ergo, we have lost our argument for holding a 15-foot setback. While I remain hopeful that the eminent domain action will not take much more than the previously agreed setback, we will see. The 1-acre parcel, which is shown on the 1961 recordation, matches the area described on the SHA piping plan to be used for future road widening. This 1-acre parcel is almost 1,100 feet long and averages about 42 feet deep. Shortly before being terminated, I contacted Erin, counsel for EYA, to warn her that while she may be planning to start the sidewalk design, Holy Cross had a serious legal action pending regarding the piping below the planned sidewalk. Erin thanked me for alerting her to the sidewalk conflict, and she notified both the state and county about a problem that they now had to contend with. This newly consolidated sidepath/sidewalk is also the same area that I thought Joseph Suntum was working on in anticipation of the state-imposed sidewalk eminent domain (ED) claim. I call this ED claim low-hanging fruit asset pending rather than a claim. I associate a claim with an argument being made in anticipation of receiving an argument in opposition. Since we have been anticipating the sidewalk ED for years, it is not so much a matter to be debated as to agreeing on value. My understanding is that Joe's forte is ED work, so it was not in conflict with the three major claims I was going to be making later. Having been terminated for over a year, I knew nothing about any changes, so I was shocked upon returning to work after my heart operation to hear that there was no action on the sidewalk ED, but that Joe's office was filing suit on the state for failing to pay compensation for an undisclosed obligation. Since Joe knows less than Chris about my 14-year fight with the state, how could he file a claim? Or to take this knowledge gap a step further, every reader of this paper will know more about this case than Chris or Joe presently knows. My earlier comment that ADW is an owner when convenient and not an owner when convenient, it is simply to control events if possible. In the present instance, ADW has filed a complaint and subsequent amended complaint stating that the state owes Holy Cross as the beneficial owner compensation. Having recently verified that the two parcels comprising the Holy Cross property are shown to be owned on September 17, 2024, by Holy Cross, what exactly is it that the state failed to pay compensation for? Do not look in the complaint for the answer, but it is a pretty good guess that since the complaint does use the word entirety in the second count, Count 2, the reference is to the shortcut. Before continuing on to what I believe to be the complaint debacle, I need to bring all to a reality check. It is clear that in 2012, and confirmed in 2016, ADW wanted nothing to do with Holy Cross. Mary Rhodes even defers to the pastor's decision not to replace the fence, for she was fearful that a section of fence not replaced by the state would lead, later, to a claim by the state to a practical adverse possession claim. So why did ADW take over my management in 2023? Mary may have been disappointed that her fence recommendation was not accepted and was slighted by my admonishment for her efforts to have the state rethink that may still have a right to the 1-acre parcel. For some reason, ADW, who had been AWOL for 11 years, suddenly emerges to exhibit some turf war tactics. Mary demanded answers inconsistent with her earlier hands-off policy. In response to her questions, I dutifully responded in detail regarding my efforts to fight the county on their effort to acquire additional ground, sidepath. In retrospect, her angst only makes sense to me now that I can see from the complaint that ADW and the state have been communicating for years, unbeknownst to the pastors or me. The state clearly feels comfortable that ADW has given them cover on their criminal activity and has now the nerve to balk at paying compensation for the land that they have taken. I say taken because if you want to make a distinction between ownership and the right to access in perpetuity, you are welcome to do so. In reading my analysis of the complaint, it states explicitly that upon completion of work to be done under the ROE agreement terminates. There is absolutely no post-ROE agreement that would allow the state to be on Holy Cross property. Whether before September 17, 2024, when HC assumed sole ownership, or after that date, the state has no right being on Holy Cross property. A month prior to Father Weibel's arrival, Mary Rhodes made an unethical contact with Erin Gerard, notifying her that she, Mary, was to be the Holy Cross contact going forward. She was to make the same contact with my engineer, Brandon Fritz. ADW had no authority to enact a gag order, as she is not a judge, but rather a lawyer representing the same client, HC, in which they have no privity of contract with me, nor authority from the parish administrator, Father Hughes. Had Father Hughes wished to have me removed, he would only have to ask me to resign. There has never been a claim against me by ADW or the parish. What would Holy Cross have done had we not performed ADW's work and confronted the state, while reserving my rights to notify the Maryland Bar Association of what both Chris and Mary have done in having me terminated? My first priority is to try to neutralize the filed complaint until such time that a properly prepared complaint can be filed. Clearly, ADW should be in a state of panic if they allowed the state access to the Holy Cross Ravine without the prerequisite documentation validating the right to occupy Holy Cross property for the state's runoff. As you will see in the enclosed documents, my specific reason for contacting Kevin Reynolds, the Assistant Attorney General for SHA, was to stop any attempt to have their illegal piping validated. While Reynolds makes reference to having been in contact with ADW and Holy Cross, I had assumed it had to do with the closing out of the ROE agreement. If, as it now appears, it was invalidating the piping scheme, I would have immediately contacted Father Weibel to inquire about what he knew about the matter. Given the fact that Father Hughes had no contact with the ADW on this matter, and that validating the shortcut is such a complex legal and financial matter, I was confident that Father Weibel knew nothing about it. In retrospect, and now with the complaints in hand, it is clear that ADW was simply trying to cover up their unauthorized granting to the state access to Holy Cross property in perpetuity. Again, in retrospect, Reynolds' email was apparently not something new, but rather ongoing. But how long, and who could have known about it at Holy Cross, particularly at a time when the diocese is in the process of transferring ownership to the parish? Ironically, both ADW and the state fully deserve being exposed for that which could not be condoned in broad daylight. Why let the state off the hook for the criminal act that is known by 3 state delegates and common knowledge in the area? Chris Anzidi has never asserted that the state did anything wrong until he, via Joe Suntum, veered into the truth in the last sentence of the amended complaint. What did Chris think I was doing for 6 years prior to the ROE deal? It is inconceivable that there was any written understanding between ADW and the state. If there had been any agreement, it would have been referenced in the complaint. When I say ADW and the state, I assume I am speaking of Chris Anzidi and Kevin Reynolds, or his associate. But what the complaint implies can only relate to an obligation both believe they had in signing the ROE. While the state is silent on any obligation, the plaintiff makes a tenuous tie to a right to compensation, which can only be to some oral understanding, or to the ROE, neither of which should be given any weight as a conveyance. Should Chris had written anything or said anything to the Holy Cross pastor, I would have known of it. As you can see in reading this paper, I document everything. But this was never reciprocated by ADW, as most all communication was to come from me. I have verified with Father Hughes that ADW never approached him about conveying property. ADW is in no position to act for the owner, who is now the sole owner, without consent and the due diligence of all to have a properly prepared conveyance agreement that can be recorded. It is clear that ADW conspired with the state to accommodate the present unrecorded state piping buried on Holy Cross property. This relationship, amplified by ADW's filing of their pathetic complaint, is a time bomb for both ADW and the state, as it cannot be explained away. For ADW, at no point in my 13-year fight with the state did they ever try to stop the flooding of Holy Cross. It is not until count 2 that we see any reference to a taking of Holy Cross property. At some time around the signing of the 2018 ROE agreement, ADW, without documentation, must have conceded to the state a right to allow access to the ravine. Amazingly, it would appear that neither ADW nor the state had carefully read the ROE, but both allude to it vaguely for support of their position. Only late in count 2 does ADW reference the devaluation of the entirety it could cause. The complaint culminated everything I was trying to awaken the parish about. The self-serving actions of ADW's cover-up, manifested in the complaint, would leave Holy Cross with only a small fraction of the award to which they are entitled. Because ADW was absent from any meaningful involvement in our fight for 12 of the 13 years, they completely overlook the criminal actions that appear to incorporate a systemic pattern. This rogue operation in Greenbelt had to have had support from Annapolis for the obvious disregard of being exposed for their actions. It is hard to believe that the millions of dollars expended on the shortcut, with the risk that it would have to be dug up, could have been from a discretionary account, without approval from Annapolis. If the complaint too meant anything other than what I state in my analysis, the drafter could have used plain English to describe the asset for which compensation was owed. The word entirety simply means to me the entirety of all the piping easements, including the creek bed. That allows the state to dump their public stormwater on Holy Cross. Since neither Mary nor Chris reflected my outrage as to what the state was doing in coercing, by means of flooding, it is no wonder that they would allow access to the ravine given their behavior. At some point, they woke up to the fact that without a recorded agreement of conveyance, they were both complicit unless they could fabricate an escape plan. Ergo, the complaint. Amazingly, there is no mention in the complaint as to what to do with the unrecorded property that incorporates all of the illegal piping. Why Joe Suntum did not reject the flimsy argument from Chris instead of going to press on it, I will never know. However, Joe is a competent lawyer and should know to conduct the appropriate due diligence before filing such a complaint. But he did not, and he now has to live with this product, or correct this mess. The state's attorneys in Annapolis must have gasped when they received something in writing for the first time that exposed their agency's SHA cover-up with ADW. Of little interest to the state and ADW, the complaint has the potential for wiping out any meaningful recovery for Holy Cross. While I cover in detail my thoughts on the complaint, the cruelest part of ADW's legal genius is to pretend that they are acting in the best interest of their client, Holy Cross. So nebulous is the claim for compensation that it appears that the plaintiff is acting more like a jilted lover seeking compassion for being betrayed. If you knew nothing about Holy Cross's 13-year history with the state, you would think you were reading about a land deal dispute, not about the state confiscating Holy Cross property and failing to pay compensation for something Holy Cross did not know about. It is clear that the drafter of the complaint knew very little of the fight I was waging for 8 years with the state, or he would not have been so cavalier. The complaint would appear to have a single issue for which the state failed to pay compensation, rather than 3 distinct major claims. Therefore, which one of the 3 claims is the plaintiff demanding payment? I conclude that the drafter thought only of compensation for the shortcut. The culmination of this ADW state joint venture can be found in the complaint's absence of meaningful words for the purpose of some sort of a desired result. The drafter of the complaint seems to be saying, "Here is a pen and paper. Give me a dollar amount you may wish to offer." We all suspect that the asset transfer is the shortcut, but the drafter, for good reason, would have to say what it is, why, when, and with whose authority, etc. If the drafter would disclose in the complaint what was provided that the state failed to pay compensation, the pastor, parish council, and finance committee would be saying, "You did what? Why did ADW think that they could transfer to the state an asset of the parish without getting approval from the parish?" Before I was terminated, I was very pleased to have had an admission from the state of their wrongdoing in having no recorded right to be on Holy Cross property. As is typical in these matters, in which admission has been stated, the state was willing to prepare a compensatory package offer for me. With an admission of wrongdoing, I was looking for compensation for their illegal trespass, flood damage restoration, piping removal and restoration, and punitive damages. Upon receipt of the state's offer, I plan to review same with the pastor, as a first offer is usually rejected, but you do the best you can to reach resolution. As a mediator, in addition to being an arbitrator, it is a delicate balancing act. The time and cost of litigation can be tremendous. My leverage was to be the public exposure that the state's actions would bring pressure on them to settle. The shortcut piping, per SHA's own plan, running from Strathmore into the southern parcel, is shown to be approximately 220 feet in length, with a 40-foot wide easement, compared to the 2,400 feet of piping that would be required when using the Strathmore RAWO. The shortcut piping of 220 feet is only part of the actual easement required, as without the Holy Cross's Ravine Creek bed to allow the public stormwater to flow to the Academy of Holy Cross, there would be no shortcut. This 30,700 square feet for the shortcut is the area of property devaluation. I had only one meeting with Chris Anzaday in August of 2023, in which I gave a very brief presentation on the state's criminality and of their refusal to stop flooding Holy Cross. My point here is that neither ADW nor Joe Suntum have the facts sufficient to prepare a proper complaint against the state. Apparently, the basis for ADW's implied intent position as to compensation is based on conversations Chris Anzaday has had with the state without our HC knowledge, which will be shown to expose ADW of malfeasance. Holy Cross, being the beneficial party in the complaint, needs to have been completely informed and to give consent to any claim being made against the state. As a member of the parish council and an advisor to the pastor, I was assured by Father Weibel that I would be kept informed of any issues relating to the state or to Holy Cross's frontage issues. While I have heard nothing from Father Weibel for over a year, I doubt that he would fail to advise me that he had been fully informed and that he had given consent to the wording of the complaint. The criminal action of the state and this complaint are the two most significant events to have happened in the 65-year history of Holy Cross. Again, I cannot stress too vigorously that ADW failed to argue entitlement in the complaint for deeds for which damages would be appropriate. We are simply left with ADW's assertion that there was an earlier understanding by ADW that the state will owe something for their taking of an undefined asset where the state had failed to pay compensation. I can only assume that ADW intentionally omitted mentioning the illegality of the state's actions, as the words implied intent relates to an understanding, not criminality. This failure to state the most material element of this case seems to have been forgotten since 2018, when the state presented the right of entry (ROE) agreement signed by ADW. In essence, the real implied understanding of this agreement was that Holy Cross knew to be a fact that should ADW fail to sign the ROE, the state would not stop flooding Holy Cross property. In actuality, it was a deal with the devil. It was at the time of the ROE agreement, 2018, that ADW had the golden opportunity to confront the state with the state's own wording in their extortion scheme. Instead, just as ADW walked away from Holy Cross in 2012 and 2016, they failed to confront the state with their illegality. In reality, the ROE agreement serves little more than a certificate of insurance for the property owner. Presently, neither ADW nor the state want to admit that there is no post-ROE agreement which would have validated the perpetual use of Holy Cross land for the state's runoff. It is the norm in these ROE deals to memorialize the actual land transaction to be recorded. ... For the complaint to argue implied intent regarding consideration, a post-ROE agreement would have provided the foundation and specificity lacking in the complaint. This omission is so obvious that one can only draw the conclusion that it was done intentionally to allow both ADW and the state to quietly exit this debacle if possible. From the outset, in 2012, when ADW abandoned HC to the criminal actions of the state for 11 years, ADW has done everything possible to interfere with my task to assist Holy Cross. It was this fear of the validation of the illegal presence of the piping that I brought to the attention of SHA's Assistant General Counsel, Kevin Reynolds, that the state acknowledged wrongdoing. It was only in reading of the complaint that Reynolds' casual comment that they had been already in contact with ADW meant anything to me. With receipt of the complaint, I could clearly see why ADW needed to terminate me. It was not, as I had previously thought, to be a turf war problem with me. Apparently, my position that the state contained their runoff to within their ROW was at variance to the discussion on access ADW was having with the state. This is not just another land use case, as the reckless actions of both the state and ADW has made a mockery of how both institutions are expected to function. At any moment now, ADW and the state could settle, leaving both parties temporarily relieved of an obligation to continue their kabuki dance. This cannot be allowed to happen, as any settlement must deal with those major elements that the complaint does not address. I want both parties to know that should the complaint adjudication process continue, or be settled or withdrawn, the method to achieve this next step is critical. If done improperly, I will vigorously pursue the party or the parties responsible. I did not work pro bono for thousands of hours over 14 years on behalf Holy Cross to have two institutions, ADW and MD, entering into nefarious behavior by a handful of their employees to the detriment of my parish. As this process continues, how could ADW continue the charade that this was just a land deal gone sour? ADW does not have the authority to exonerate the criminality of the state's actions, nor to agree on compensation. Since both parties have failed to show any common sense in this matter, Only an objective body should examine the actions of both parties and to rule accordingly. While the actions of ADW have followed an illogical pattern and greatly damaged my work for the parish, the actions of the state stand alone to be judged. I would far prefer to have this case go to trial rather than to see further tampering with what I truly believe is a time bomb, the complaint, in which Holy Cross goes from victim of the state to a worse condition caused by ADW. At this point, I need to stop and ask the reader to reflect on what I wrote earlier. If there is no agreement between the parties, why go further? Case closed. Furthermore, I had already received an admission from the state that absent a recorded right of access, their installed piping was illegal, warranting removal and damages. Since ADW's complaint lacks any reference to any agreement in which the state has an obligation to perform, why would it be any surprise that the state would file a motion to dismiss? Having no record of any deal being made, I had personally paid a land use attorney for her services to obtain any such agreement. ADW would not respond to my attorney's request. While my claim was to include very substantial punitive damages for the state's trespass, restoration, and property confiscation, ADW seems prepared to accept almost anything just to get out of the mess they helped create. Having failed to do anything right, ADW could not just let the state take adverse possession of this 30,700 square foot easement without some response, or they would look like a fool. So, what do? They double down on their incompetence. Having no substance, their complaint has the potential for allowing the state to claim de facto possession of this confiscated ground in 2018 without waiting 20 years, 2038, for the cover of de jure. I was expecting an eminent domain claim to be made at any time. Clearly, Joe knows little about the background of this case, and Chris knows little to tell him. I was only given about a half-hour exposition to Chris in August 2023, when he showed little interest in the historical facts of this case. At this meeting, Chris dominated the conversation, accusing me of having failed to follow the procurement protocol of ADW for the restoration of the damage to Holy Cross on work that was their duty to perform. To this, I would suggest to Chris to visit the principal, Lisa Kane, to see if she could live with another year of delay to accommodate his procurement protocol. This is yet another example where ADW asserts ownership of this parish property when convenient, and goes AWOL when convenient, without apology. My failed effort to get ADW to perform their duty in 2012 did not end my efforts to get their attention. When in 2016, my neighbor and MC council member, Nancy Florine, agreed to convene for me SHA and MC officials on the Strathmore flooding issue, I invited ADW's rep, Richard Distolinsky, to attend. Richard was the ADW rep who told me in 2012 that ADW did not have the money to fight SHA. He not only failed to present ADW's strong condemnation of the state for their actions, he simply stated that, when this matter is settled, ADW owns the property. 8 years later, ADW no longer owns the property, but their disastrous legacy lives on. There is a subtext to what I have written above, and that is that while I found myself caught up in a perfect storm of criminality and incompetence, I would do it again if the same conditions presented themselves. With canon law shedding diocesan real estate to the parishes, pastors, as decision-makers, are going to be needing more parishioner expertise coming forward to assist. I have no doubt that if the pastors take time to listen carefully to a variety of views, they will be far better off than the present system. Understandably, as in the present case, an inexperienced and new parish administrator would rely on the norm of deferring to the diocese on matters of such importance. What this new administrator and parish guardians did not know was that the General Counsel for ADW had a prior history in the affairs of Holy Cross that were not disclosed. You have to ask yourself why ADW would avoid any obligation to protect their own property for 11 years, and then suddenly find it imperative that they save the parish from me. The answer is that ADW had something to hide, and it can be found in the subtle wording of the complaint. A year prior to ADW using Joe Suntum to file the complaint, I had already received the state's admission of wrongdoing, and Holy Cross was waiting on the state's compensation package. It is as simple as this. Unbeknownst to Holy Cross, ADW had provided a get-out-of-jail deal for the state as early as 2018, and it was critical that this deal not be disclosed. ADW makes no assertion in the complaint to any state wrongdoing. How sweet this is for covering up ADW's failure to confront the state for over a decade. ADW correctly speculates that my claim will incorporate a claim for punitive damages. Since ADW is only looking for unpaid compensation on an oral implied intent understanding, punitive damages would suggest wrongdoing. ADW appears to be looking for only chump change to cover access, property devaluation, restoration, and their own acts. I am livid that ADW offered the state any deal without the knowledge and consent of Holy Cross for what they, ADW, were selling for an undefined compensation amount. As the preface of The View from Under the Bus indicates, I remain open to hear anything that I may have missed to fill out the narrative of events. While the HC position has been unchanged since 2010, i.e., Holy Cross has no obligation nor has given consent to have the state's public stormwater deposited on their property. All the evidence that I have previously provided suggests that ADW did not hold that position and that they did in fact provided accommodation to the state, allowing for access. In a stunning reversal, the concluding sentence of the amended complaint, Count 3, demands ejection of the defendant and its drainage facilities from the plaintiff's property. Plus, this is great news, but as my concluding comments in my analysis of the amended complaint note, reversing the actions of the state and ADW in the present court action will be challenging. I question that ADW has standing in court, as they stated that they were the owner of the property when they filed the amended complaint 10/8/2024, whereas Holy Cross was recorded as the owner a month earlier, 9/17/2024. There is no question that the state cannot show any recorded right of ownership or right of access or any pending action by the state to assert that right. The ROE agreement is not a conveyance agreement. However, the state would like to allude to this document and the possible consent by ADW that was the basis for the plaintiff's implied consent argument. Thanks to the intervention and the incompetence of ADW, following their failure to confront the criminal actions of the state, HC remains a victim to these two institutions and finds themselves mired in a senseless court action. Yes, the actions of ADW are reprehensible and deserve severe review and exposure for their incompetence. And yes, it is absolutely shameful that in being abandoned by ADW to this day, ADW has done everything possible to deny Holy Cross proper justice and recovery. But that is for another day. The actions of the state stand alone for audacious criminal action against a private property owner. Since 2010, when they initiated the nefarious strategy to coerce our parish into submission for their self-serving benefit, I have never seen a government entity so recklessly in pursuit of their unlawful goal. This case needs to be heard in court, so that the public fully understands the treachery that state agency, SHEA, has the potential for doing. My summary and conclusions may be found at the end of my analysis of the complaint.